Good morning, Wisconsin. This is Dana Zulik. Welcome to Local Wars. So, I'm going to try something a little different today. I'm going to pre record this and post it right away. I had a friend tell me that pre recorded is better if he sees live streams, then he kind of gets like he doesn't look at them as much. He prefers to watch live. So, I'm going to run it more like a live because that's how I do it. But since we don't have a lot of viewers viewing the lives yet, since we're so new, it's okay. We're just going to go with it. So um, today it's going to be a deep dive. And the topic is, why did the chicken cross the road? Guys, I can't even start to tell you. Chicken. Why did the chicken cross the road? So when all of this started with the scenic pit, the neighbors seemed to find the easiest way to retaliate was my animals. And we would be here all day if I went through every picture, video, that I have of evidence that our fences have been cut, our fences have been tampered with, gates destroyed. I had put up 3 separate fences over the years. In fact, Deputy Bouts of the Washington County Sheriff's Department had actually testified under oath that he's seen me construct 3 separate types of fences, a wood fence, a metal fence, and an electric fence. And as you know, if any of you out there have animals or know anybody that has animals, from time to time they get out, and that's something that we don't like to happen. We like to keep the animals safe. We like to keep the community safe. And it got really frustrating because at one point I just had to rehome all of my animals. And then when I thought things had calmed down, we got some animals again. And then it just always seems to be something. So I have had evidence of baiting. So like beef jerky thrown into the shoulder across the road from where I live. And animals are going to stay where their water and food source are, and I like to free range my chickens. I'm not the only one in the community that free ranges. There's free range chickens all over Richfield, and typically they'll stay in the yard, but if there's a yummy treat, then they'll cross the road. So the answer, spoiler alert, in this case, the answer to the question, why did the chicken cross the road? Well, it's so that I get a $515 fine. And I've counted over 100, but by the time I've acquired about 100 tickets, but by the time, sometimes they'll combine them into one. In the earlier stages, I would try to work with the district attorney's office. And keep in mind, while this is all happening, I'm telling the district attorney's office what's happening, this collusion that's happening, this campaign of harassment that's been launched by the Village of Richfield with the neighbors to try to run me out of town. Get out of our town. We don't want you here. It's just anti-American. It's not the way things should go. It's not the way things should be. So, despite all of the critics out there that have constantly told me, I live on a hobby farm, guys. I'm telling you, I don't know what it is, but I've got like 3 flies in my room that I can't seem to. Ugh. Anyway. So they made me lose my train of thought. Here we go. So anyways, the critics out there like to say that I don't take responsibility and that I'm just like placing the blame and not wanting to solve the problem on my own and do the right thing and be more responsible. And I hear that. I hear from their perspective how that seems to be the case. However, it's not as simple as that. And I just am enraged. I'm angry, guys. Sometimes to make changes in your community, you have to get angry. You have to be mad. I have anger. And I have tried very hard in the last 10 years to rein it in and sort of, try to hold my composure. And one of my favorite podcasters, Melanie Little, she always says, keep it classy. And so, that I've been working on it. I've been working on trying to keep it classy. I have a couple issues with my background that it causes me to maybe not be so classy. I mean, I am a combat veteran and I work with construction truck drivers all day long. So you can imagine that gets a little fun. So today we're going to go over this case. I have some trials coming up. The most recent way that the district attorney's office has been handling my animal at large cases, because I asked for a jury trial for each one of them. And I just recently had 2 of them dismissed. And the part that frustrates me the most is that they don't just dismiss it. It's not like the district attorney's office gets the case and they're like, oh, we're just going to dismiss it. No, I have to go through all of the pretrial steps. So you have to pay a jury fee. So you can request a jury, you pay a jury fee. It's not a very large fee, but a fee nonetheless. It's about, I think it's $36. And then don't quote me on that though, but it's not a big number. But so for each trial, you have to pay a jury fee. And in this particular case that was recently dismissed, they not only did I pay for the jury trial, but we had a briefing schedule on a jurisdictional issue, because my argument is, since local approvals have been removed and the courts have determined this twice at the Court of Appeals, that arguably the statute in the Wisconsin law that grants the authority for local governments to issue animal tickets is actually enumerated, which means it's listed in the list of local approvals in Chapter 289 to solid waste facilities. So the argument, as silly as it might seem to some people, what does a chicken have to do with a clean fill facility, Dana? Well, I think it has a lot to do with it, especially if it's being used as a weapon to harass my family. And when I say my family, I mean, I suppose it's to harass me, but in turn, it puts a lot of stress on a family. It really does. It's just a lot of chaos, I guess you could say. Undue stress. So keep in mind, these people also know, they're well aware that I am a combat veteran and I do suffer from PTSD. Sorry about that, guys. I guess when the phone rings, it kicked me off, so I couldn't figure out how to swipe myself back on. But I kind of forgot where I was at. Oh, PTSD. So I have a service dog who actually, her name is Pepper, and she's amazing, and she travels with me. She flies on airplanes. When I went to get some PTSD treatment at the VA last year, she lived at the VA with me for 6 weeks. And you're going to hear me be very, very frank about mental health, by the way, guys. If you feel uncomfortable, or, I guess I could give a little trigger warning, because I tend to already be an oversharer. It's I guess it's a bittersweet quality that I have, because I do open myself up for more criticism. But at the same time, part of the goal of Local Wars is to end the stigma on mental health, because quite frankly, Isn't it so easy to just, when somebody's already struggling with mental health or another issue, isn't it easier for them to sort of just throw more mud at the wall and see what sticks? And it's my belief and opinion, based on my experiences and what's happened to me, that this is exactly what they're doing. And they know that I struggle. I have been honest with them about my struggles, and yet here we are. They continue to keep doing these same things. So going back to the case, uh, this particular jury trial that was dismissed, we did a briefing on jurisdiction and whether or not, you know, they even have regulatory authority, the sheriff's department, to issue me these citations, given that the state of Wisconsin has tried to remove um, the local government from regulating sites like mine, and the purpose is to prevent discrimination. So, I mean, in my opinion, it doesn't make sense if they're trying to prevent discrimination, and there's this one ordinance that they think they can apply, and they've done it over 100 times. It just doesn't pass the sniff test to me. It's just bizarre, very bizarre. So we're going to go into a deep dive. We're going to read over this motion that was filed and briefed out. I am going to tell you, in the end, this case ended up being dismissed. One of the reasons they said was that the witnesses were not willing to come testify. And in the district attorney's opinion, if they're going to call and make this complaint and then not show up to the trial, will then kind of lose their ability to prosecute the case. And but that wasn't until we did jury selection, we had pretrial hearings. I mean, the time. So wait till you see this brief, guys. This brief is pretty impressive. Okay. So I'm going to just share my screen. I'm not quite sure how to do this. Oh yeah, that's right. I do it like this. Do we like it like that? Or should we go with, I'm so little? That's okay. There, maybe that's a good compromise. How about that? Okay. So, I'm going to go through this document. So we're going to start here. Defendant's brief requesting dismissal of 2023 FO 001264 and another case due to lack of jurisdiction pursuant to Chapter 289 Wisconsin statutes as interpreted by Scenic Pit LLC versus Village of Ridgefield. So it says, please take notice that I, Dana Lee Zulik, the defendant, respectfully request that this court dismiss two above referenced cases due to lack of jurisdiction pursuant to Chapter 289 Wisconsin statutes as interpreted by the Wisconsin Court of Appeals in Scenic Pit versus Village of Ridgefield. And a complete copy is attached. Last year, on September 13th of 2023 and October 24th of 2023, the Washington County Sheriff's Office issued two animals and poultry at large citations to me under Washington County Ordinance 172-11 for animals residing on my state-regulated clean fill site located at 609 Scenic Road. Chapter 59 of the Wisconsin statutes confers upon Washington County the authority to enact and enforce this ordinance subject only to Constitution and to any enactment of the legislature which is of statewide concern and which uniformly affects every county. See section 5903(1)(2). Okay, so basically what this is saying is exactly what I told you in the intro, is that, you know, the state of Wisconsin regulates clean fill facilities. Therefore, this specific statute that gives the county the authority to issue this ticket has been removed. Okay. Wisconsin legislature has determined that clean fill sites like my property are of statewide concern under Chapter 289 and thus are exempt from any county and local regulation under the definition of local approvals in section 289-33-3D. And that's as interpreted by DeRosa Landfill versus City of Oak Creek, which we went over in another stream. You're welcome to go back and watch that live stream. I kind of go into that and explain the history of case law. Those local approvals include several enumerated sections of Chapter 59 Wisconsin statutes and giving counties the power to enact ordinances like 172-11, which is that animal at large poultry, which our state legislature has expressly withdrawn the county's power to enforce against clean fill owners and operations like me. Furthermore, the Wisconsin Court of Appeals has held that the definition of local approval in section 289-33-3D Wisconsin statutes is not limited to the statutes enumerated. So not only is it enumerated, but it's not limited. That's how broad this statutory scheme is for Chapter 289. And in fact, in our case, it says, in our decision at the Court of Appeals, it says that it's a broad, it covers a big umbrella full of things, right? It's for this reason, to prevent discrimination. That regulatory, the Washington County ordinance regulating animals and poultry at large cannot be enforced by the county or local authorities against me. That regulatory authority is vested exclusively with the Wisconsin Department of Natural Resources under section 289-43-8 and Scenic Pit LLC versus Village of Richfield, because the Washington County Sheriff's Office lacks the authority to enforce Ordinance 172-11 against me as a clean fill site owner regulated under section 289-43-8. This court must dismiss both of these issues cited due to lack of jurisdiction over this matter. So basically, a lot of people might argue, well, then are you allowed to just let your animals run around? Well, no, there is an enforcement mechanism. It's just not to be in the local government hands. It's, they can report and file a complaint with a warden through the DNR. And that is, in my opinion and belief, and speaking to my attorneys, the way that it should go. That is the enforcement mechanism if there's a complaint of animals at large. Since May 2015, I have owned the 40-acre property at 609 Scenic Road in Colgate, which is regulated and permitted by the Wisconsin DNR. See the DNR certificate of permit coverage issued to me attached. Despite the fact the Wisconsin legislature has given the DNR exclusive authority to regulate my property, including the animals which reside on it, the Washington County Sheriff's Department, Washington County and Village Richfield officials, and a small handful of nasty neighbors who do not want me to operate my clean fill site have launched a well-coordinated campaign of harassment against me. The primary tool they have used to harass me is the Sheriff's Office issuance of numerous animal poultry at large citations and making multiple visits to my property over nearly a 9-year period. First, since 2015, the Washington County Sheriff's deputies have been dispatched to my property or otherwise harassed me at least 655 times. Yep. 655 times, guys. And keep in mind, this is in March. So how many more times has it been? It's so, like, when you see the numbers put down like that, it's every time they come out to my property, they're like, oh, this is a separate incident. It has nothing to do with that, Dana. It has nothing to do with this. It has nothing to do with that. I show them evidence of the collusion. I show them emails. I show that falls on deaf ears. Since 2015, the Washington County Sheriff's Office has issued at least 63 citations. So that's what we have on record. Because remember, I told you some of them get combined and lowered. For animals and poultry at large citations costing me over $32,000 in civil forfeitures. Third, in an October 31st, 2018 letter to me, former Washington County Sheriff Dale Schmidt threatened me with jail time for future animal at large convictions, even though he knew that failure to pay forfeitures for county ordinance violations is not punishable by jail time. Compare it to the former Washington County Sheriff Dale Schmidt's October 31st letter with current Sheriff Martin Schulteis September 17, 2019 email response to Richfield Village Administrator Jim Healy, attached here as Exhibit F, showing that the sheriff knows that jail time is not a legal option under the law for unpaid civil forfeitures related to ordinance violations. So they wanted to put me in jail. They threatened to put me in jail twice. So the first time they said we could put you in jail, knowing that they couldn't put me in jail. And then the second time, I believe it was Jim Healy, but we'll get there when we get to the exhibits. But they basically wanted me in jail. Fourth, in his September 17, 2019 email, Sheriff Martin Schulteis admits that I am being treated differently than any other person in the county cited for animals at large. See Exhibit F as attached. I requested a personal meeting with Sheriff Schulteis to discuss this acknowledged and grossly disparate treatment of me, and he refused to meet with me on this matter. My state legislator, Representative Janelle Brandtjen, also is outraged that the sheriff's office is treating me differently at the behest of Richfield Village Administrator Jim Healy. See the November 4th, 2021 email from State Representative Janelle Brandtjen's office. Fifth, Richfield Village officials, primarily the village administrator Jim Healy, have been colluding with the sheriff's office, Washington County Executive Josh Schoeman, and a few disgruntled neighbors to keep issuing me more animal at large citations. See Richfield Village Administrator Jim Healy's January 20th through 23rd, 2020 emails to several members of the Sheriff's Department and County Executive Josh Schoeman's May 8th, 2020 email to two of those disgruntled neighbors, former County Board Chairperson Don Kriefel, Richfield Village President John Jeffords, and Jim Healy, all attached here as Exhibit I. Legal rationale for state preemption and withdrawal of county power to comply with local approvals like County Ordinance 17211. Wisconsin Court of Appeals Judge Brian Hagedorn, now a Wisconsin Supreme Court Justice, said it best in his opening remarks to the Scenic Pit versus Village of Richfield case. The siting of landfills is understandably often fraught with controversy. In response, the state of Wisconsin is seen fit to preempt local neighborly battles for the common good by establishing a statewide landfill regulatory scheme. So I want to read that again because this was the big decision that allowed us to start operating our site. The Court of Appeals only has a couple oral arguments a year, and ours was one of them that year. And it was, it ended up being a pretty big deal that the Court of Appeals had an oral argument, and then they reversed the circuit court's decision and unanimously said that the Village of Richfield does not have any regulatory control over the site. So I'm going to read it again. The siting of landfills is understandably often fraught with controversy. In response, the state of Wisconsin has seen fit to preempt local neighborly battles for the common good by establishing a statewide landfill regulatory scheme. See Scenic Pit LLC versus Village of Richfield. So I'm citing my own case law. The case law on this issue is literally my own case. So I didn't even have to find facts similar because it's my case. A lot of times case law is, applied when you find facts most similar, and it's hard to find facts that are so similar. But in this case, it is my case. So the state preemption and withdrawal of county and local power to enforce local approvals like Washington County Ordinance 17211 is necessary to avoid arbitrary or discriminatory policies and actions of local governments which obstruct the establishment of solid waste facilities. See footnote 7 of Scenic Pit LLC versus Village of Richfield. The grossly arbitrary and discriminatory actions of the Washington County Sheriff's Department in collusion with Richfield Village officials and a few vocal nasty neighbors against me is exactly why the Wisconsin legislature established Chapter 289 of the Wisconsin statutes to preempt and withdraw the power from the county to enforce Ordinance 172-11 in cases like mine here. Since 2015, The continued collusion of the sheriff's office, Richfield village officials, and a few nasty neighbors has resulted in 655 deputy dispatches to my property, 63 animal at large citations, over $32,000 in civil forfeitures, and other forms of privacy invadement harassment regarding my property. See Exhibits C and D. Sheriff Schulteis has blatantly admitted that his office treats me differently than any other person in Washington County cited for animals at large. See Exhibit F. For 9 years now, my Cleanville site in Richfield has been fraught with controversy, resulting in the previously described harassment. According to the Wisconsin legislature and Wisconsin Court of Appeals, the only way to quell that controversy and end this local neighborly battle is to preempt and withdraw the power of the Washington County Sheriff's Office from enforcing Ordinance 172-11 against me and place that enforcement power exclusively in the hands of the Wisconsin Department of Natural Resources. See Scenic Pit versus Village of Richfield. That is exactly what both Chapter 289 Wisconsin statutes and Scenic Pit LLC versus the Village of Richfield require to happen here in my case. Washington County Ordinance 172-11, which derives its authority from Chapter 59 Wisconsin statutes, is a local approval that has been preempted and withdrawn by the state legislature as defined under Section 289 33(3)D Wisconsin statutes, and such definition is not limited to those county and local laws enumerated therein, according to the Wisconsin Court of Appeals. Sheriff Schulteis' admission that his office treats me differently than any other person cited for animals at large is in direct violation of the federal Constitution's Equal Protection Clause of the 14th Amendment. See Exhibit F. This is known as the Class of One Doctrine, an action under which can be brought by an aggrieved citizen in federal court under 42 U.S.C. 1983. The U.S. Seventh Circuit Court of Appeals, of which Wisconsin is a part, has extensive recent case law holding that a pattern of discriminatory behavior is sufficient to support a Class of One equal protection claim, even in the absence of a similarly situated individual. Here we have Sheriff Schulteis acknowledging that his office has discriminated against me for over 9 years now. The Washington County Sheriff's Office, in collusion with Richfield village officials and the few nasty neighbors who oppose my Cleanville site, has shown substantial animus and a continuing misuse of power by its government agents, akin to an orchestrated campaign of official harassment motivated by sheer malice. See Olick versus Village of Willowbrook. Also see Brunson versus Murray. Pervasive pattern of harassment was sufficient to create a cognizable constitutional claim under Equal Protection Clause's Class of One doctrine. This discriminatory governmental conduct and disparate treatment is evidenced by 655 sheriff's deputies dispatched to my property, 63 county-issued animal at large citations, over $32,000 in civil forfeitures imposed, all of which so clearly suggests no conceivable legitimate purpose other than to run me out of town and close down my Cleanville site in the village of Richfield. See Exhibits C and D. Because this blatantly governmental discrimination and disparate treatment of me, I have retained a highly experienced constitutional law attorney and will be filing a federal lawsuit under 42 U.S.C. 1983 very soon to hold the Washington County Sheriff's Office, several Washington County and Village of Richfield officials and other governmental actors and agents fully accountable for their collusive, discriminatory, harassing conduct in violation of the 14th Amendment's Equal Protection Class of One doctrine. Conclusion and request for dismissal. Now keep in mind, well, I'll get to that at the end, but it's the response brief from the district attorney's office looked like something somebody does in high school. If even, maybe junior high. It's like in letter form, very simple. And there said, well, Judge, animals aren't part of a Cleanville facility. That's too broad. Wow. And the interesting part is I was going to actually appeal that decision because the circuit court, the same one that ruled against us in the early stages of the circuit or of the Scenic Pit case versus Village of Richfield, they ruled in Richfield's favor at the circuit court level. It took the Court of Appeals to have an oral argument and unanimously reverse. the circuit court. So I don't have a lot of faith in our circuit court here in Washington County, because when it comes to this issue, they're just going to try to, wash their hands of it. Oh, it's too broad data, and so I had even told the courts I didn't know whether I was going to do an interlocutory appeal on that decision when they ruled in the district attorney's favor rather than mine on this particular brief, which also was insulting, because I believe that this is a scholarly brief and it's very persuasive, and to give it such a response that was just so elementary in its content, it was just insulting. But anyways, I was going to appeal it at the depending on what the jury's decision was, but we went through all of this to just have them dismiss it anyways. So this issue still has not been adjudicated, this jurisdictional issue. So we're going to have to see about that. Wherefore, because the Wisconsin legislature has preempted and withdrawn the power of Washington County Sheriff's Office to issue animal at large citations under Ordinance 17211 to clean fill site owners, and has given that power exclusively to the Wisconsin DNR under Chapter 289 Wisconsin statutes as interpreted by Scenic Pit LLC and Village of Richfield, the Sheriff's Office lacked the legal authority to issue the 2 citations in this case. Accordingly, I respectfully request that these 2 animal at large cases be immediately dismissed due to this court's lack of jurisdiction over these matters. Okay. So this is the Scenic Pit decision that came down. The oral argument was August 17th of 2016. The opinion was filed June 28th of 2017. In here, the siting of landfills is understandably often fraught with controversy. In response, the state of Wisconsin has seen fit to preempt local neighborly battles for the common good by establishing a statewide landfill regulatory scheme. This case concerns the scope of that statewide scheme for solid waste facilities exempt from regulation under Wisconsin Statute 289-43-8. Okay, so we can go through this case another time. I'm not going to spend too much time on it today. Here's an interesting part, though. The legislature saw fit to add an unusually extensive list of legislative findings motivating the statewide regulatory scheme here. Among the highlights, the legislature notes that solid and hazardous waste is unavoidable and used by everyone, but that it often raises legitimate concerns by neighbors. In view of these things, the legislature indicates their intent was to create a comprehensive policy overseeing solid waste disposal and hazardous waste facilities to avoid arbitrary or discriminatory policies and actions of local governments which obstruct the establishment of solid waste disposal facilities and hazardous waste facilities, all while considering the views of local citizens and protecting the environment in an economically viable way. So that's that. I think there's a cool footnote in here. Melanie Little always talks about footnotes. She's like, I love footnotes. Let's see some fun footnotes in here. I think there's a couple about the village. So if we go to well, I'll have to find the other one where it has the footnotes more obvious. I'm not an attorney. Disclaimer, I'm not an attorney. Certificate of permit coverage. Okay, so guys, I'm just going to scroll super fast, but this is the evidence of the call logs. Look at this. This is the call logs. As I scroll, call log, call log, call log, call log. These are all the dispatches, so the receipts of all of the times they've come out to my home. Here's a list of the citations. I'm skipping over it because there's, I didn't take the time to go through and redact all of this. And as much harassment as these people have given me, and I do mention quite a few names, I try to stick to public officials' names and things like that. The neighbors, I did name the neighbors to the south in one of the episodes. But, for now, I'm just going to kind of minimize that. Okay, so here's the October 31 letter. Dear Ms. Zulik, recently Lieutenant Stacer attempted to contact you in regards to multiple animal at large violations you have been cited for, and to advise you that under Washington County Code, it is possible for a person to be jailed for failing to pay citations for which they have been convicted. There is an estimated 17 separate animal at-large complaints investigated by the Sheriff's Office in regard to multiple animals owned by you. You have been issued multiple citations in regards to these violations. At times you have been simply warned. At other times it is believed your animals were loose, but deputies did not have sufficient evidence to issue citations. The purpose of the ordinance is to ensure animal owners properly secure their animals. When they are not, animals can damage others' property, be danger to people, and be in danger themselves. For instance, a horse in the road could be struck by a vehicle, injuring people or the animal. Also, on multiple occasions, you have been found in default on citations and failed to pay the monetary fine. Since it appears issuing you citations has not had the intended effect, properly securing your animals, the Sheriff's Office has asked the District Attorney to request of the court jail time for any future convictions for which the fine is not paid. Okay. Every time there's been an issue and I have evidence of tampering with fences, I give them pictures, I explain the situation. I need to get a chart because these things go in like clusters, right? So like, I'll give you an example of the electric fence situation. An electric fence works because of the circuit, right? So if I have a 40-acre parcel and I had about 8 acres that had electric fencing. So if somebody goes along the line anywhere, like I put up cameras and stuff, but it's like a quarter of a mile long boundary line, right? So if somebody goes in the woods, they cut the fence, that the circuit's gone, that there's no more electricity to keep the horses in. So I ended up having to build a wooden enclosure, out of a wood fence. But that sucks for the horses. They deserve to be able to have open space to graze and, wander. They shouldn't have to be held into this confined little paddock, which just sucks. It really sucks. And the one deputy, when he came, I had, said, you need to come look and see where this fence has been damaged. And he literally said, like, we're in the woods where this fence has been cut. And he says, well, there's no hoof prints on the other side. And it took me a while. I'm like, what is he talking? Oh, you think the horse got out right there? No, that's not how this works. If there's no electricity, the fence, the horses are going to, they're going to challenge the fence. They're going to try to push through it. And, horses are smart animals. A lot of horses, if they just hear the click of the electric fence on, they hear the ticking, snapping sound, that's enough for them to not even try. But if there's no electric current, they know. The ones that are not as respectful of fences, or they're just going to try. They want to go look at the world, eat some grass. Anyways, so here is penalties. We listed in default of payment of such forfeiture and costs will be in prison. Costs paid such a person to exceed. Okay, so I'm not sure. Let me see here. Okay, hold on. I'm not sure which order these all go in, but let's just go ahead and get at it. I know everyone is frustrated. This is from Josh Showman. It's my firm belief this is a village issue. Although county sheriff is the contracted law enforcement agency, the village still has jurisdictional authority, so to speak. If the village has its own law enforcement agency, not that I'm advocating for such a foolish move, would anyone be considering asking the county attorney to intervene? I don't think so. While I'm certainly willing to collaborate with the village, I like to call it collude, in my opinion. Which I feel we have demonstrated time and time again. As long as there is an avenue for the village to pursue, I will not be inclined to support county involvement. I am willing to be open-minded. If I am wrong, then I will certainly reconsider. However, after my conversation with the sheriff and the county attorney, this seems to be a village issue that the county has no business getting involved in beyond our partnership as contract law enforcement. I stand ready and willing to work together when and where appropriate. So this one is from Martin Schultes. We share your frustration on this. We have explored several enforcement options here as well. We have dedicated countless hours to investigating complaints, taking enforcement action, escalating our enforcement, researching lawful authority, and providing additional options. We continue to cite with the escalated bond amount when we have a documented violation. This is the only enforcement avenue we currently have. I would like to see one of the three options put into place. And then this is where he says, I would argue the offender is already being treated differently than any other person cited for animals at large. Like, they put that. Like, why am I being treated differently? He tried to explain it away when I confronted him on it. He tried to say, well, we could give you more tickets. Well, either way, you admit in black and white, like right here, literally, the words that trigger a Section 1983 violation. Like, you're admitting you treat me differently. They painstakingly went over chapters 172 and 173 and do not think we have the authority to seize the animals at large without a specific court order. They want to take my animals. You know, let's keep in mind, there's absolutely no accountability being held towards these people at all. None. Failure to pay for a county ordinance was at one point punishable by jail time. This process is no longer utilized with the inception of tax intercept. We have broached this as a solution, and the hesitation is that this offender would be treated differently than other violators. That's your hesitation. Hesitation. Not, we can't do that. They're hesitant. Okay, here's by Jim Healy. A village resident stopped into Village Hall to complain about Ms. Zulick's horse. To complain about Ms. Zulick's horse that was in the road yet again. Our residents are sick and tired of having to dodge farm animals. Well, maybe if you looked into why this is happening, I'm either the worst fence builder since the beginning of mankind, or there's something else happening, right? Here's where the sheriff was like, I'm not certain what you would like to discuss. I have personally met with you on different issues in the past, but the copy of the open records email that you obtained is pretty straightforward, and I stand by each of these points. We have never had such a chronic problem of animals at large as we have on your property in all of Washington County. Okay, well, I also was involved in a very public case with the Village of Richfield about operating my clean fill site. So that's unusual too. So basically I was a law-abiding, compliant citizen until I miraculously decided to be completely I decided to take all of the laws and just, I'm not going to follow them anymore, guys. I'm going to be a completely different person. No, that's not how that works. How that works is they're upset and they found a way to harass me. They bait my animals, they cut my fences. You know, I'm gonna share an audio with you that I have of the district attorney, Mark Benson, when I tried to show him evidence of all of this stuff happening, and just the snark he gives me and the disdain. It's just, I'll let you listen for yourself. Okay, so there's this, it's just so, it just keeps going. This is all of the inner workings of the county and Richfield officials trying to figure out what to do with the animal issue. So this is from Jim Healy. The village attorney is also researching, village attorney is John Macy, whether the property owner, emphasis added, not Ms. Zulik, should have an action brought against them declaring the situation a public nuisance affecting health pursuant to Village Code 263-5F. This provision specifically enumerates all animals running at large as outlined in section 118.11. I look forward to discussing this with you in person. Who is this to? Oh, the sheriff. Okay. This is from Martin Schulteis. The agency has been struggling for a long time regarding all sorts of animals running at large at the 600 block of Scenic in the village of Richfield. It's exponentially increased over the past several weeks. Well, let me tell you what happened in the last several weeks. Okay, it's not like this just randomly starts happening, guys. So I had gone to Florida, and I believe it was in December. So basically a month before all of this. And while I was in Florida, I get a call, or I get contacted by my attorney for the boundary dispute case with the Petrosatis, who had sued me for $70,000 over a boundary dispute. And he contacts me and he says, we won, as we knew we would. We won. So I'm celebrating with my friends in Florida, and then it occurs to me, oh crap, I'm not there. And if history repeats itself, well, I'm going to start having okay, this is getting ridiculous in here. Okay. If history repeats itself, I'm going to have ponies running all over the village. So me always thinking they're going to do the right thing, right? Which clearly, guys, the evidence here should say loud and clear. They're not going to do the right thing, the sheriff's department, but in good faith, because of the history of how things happen, these vandalism seems to happen at the same time as a decision in the courts. So like, what if we win a case, then all of a sudden there's this uptick in all of these instances. So I in good faith, I call the sheriff's department and I just say, heads up, I'm in Florida. Okay, I'm not there. And I just found out I won that boundary dispute case. And it is my belief that Petrosatis has been responsible for the vandalism. Okay. And I said, if history repeats itself, just like I told you guys, if history repeats itself, we're going to have ponies running all over the village. So I get a call within days. Maybe the next day, 2 days later, there's ponies running everywhere. My neighbor sends me a picture. A neighbor that I get along with sends me a picture of where the fence was cut in 3 different spots. He tries to, put up fencing till I can get back to Wisconsin. So I get back to Wisconsin, and now I've got this huge issue, and it's snowing and it's in the middle of winter, and I'm trying to figure out how to keep the horses in now that the circuit's been cut. And it turned into a huge nightmare, and the horses ended up getting out numerous times in a few week period until we got it back under control. But that wasn't until a neighbor actually called the news and they did a news story on it. So I'll show you guys that too. Then the last thing I want to show you is these are some neighbors that live down the street. And when I say that these people follow me on CCAP and they coordinate their strategies based on what's going on in court, I mean, they'll follow things for my divorce and property and all these things. And they'll like coordinate how they're going to, like, what their next step is in harassing, like keep the pressure on her. They even say that. So this is the evidence of those neighbors. Here we go. You put my CCAP record. Look at this. Like, do these people have anything else better to do? Like, the courts made their decision, but no, we're not done. We're going to obsess. We're going to obsess. Someone, I heard the other day, this was just a few weeks ago, someone told me that our neighbor, Paul Craig, who wrote this one? Was it Marilyn or Paul? Marilyn and Paul. Okay. They said that his favorite 3 topics include talking about Scenic Pit and Dana Zulik. So like, it's like something like the Lions Club, the church, music, something, and Scenic Pit. Those are like his 3 favorite things to talk about. I don't know because I don't talk to him. I've met him a couple times, but no, the amount of harassment he and his wife have caused me is quite great. There should be a police report where she was actually stopping truck. Like, she stopped a truck driver in the middle of Scenic Road and told them they weren't allowed. Like people like call companies when they're hauling, and they'll, one time I got a call and they're like, Dana, why aren't we allowed to dump at the Scenic Pit anymore? And I'm like, what are you talking about? Well, somebody from the Scenic Pit called and said that we were no longer welcome to dump there. It never ends. Guys, I'm telling you, starting a business is hard enough, but this many hurdles. So somebody literally is calling companies and telling them they're not welcome to dump here and pretending to be one of, like, the Scenic Pit workers. It's gross. Okay. So let me see if I can manage. Let me see how this works. Hopefully it stays on the same